Congratulations. Sir, one information regarding the. Actually, I couldn't attend the class yesterday. I didn't get the ticket. And what about the holidays regarding the Easter and all?
That I don't know.
You don't know who is the person in charge?
Principal.
Principal sir will know. I want to reserve the ticket for the only Thursday and. Okay.
Click one more.
Sir, Good Friday is holiday here.
You ask principal.
Only.
Principal.
Okay, I will ask. Good Friday is actually not holiday.
I don't know. You ask the principal. Job 6. Sit down. Right? Once you come into the class, they will give something. Something is a subject in the mind. Yes? Have some knowledge in the mind. Right? Yesterday, we have seen. Right. So yesterday we have seen what is meant by arbitration, right? Different types of different types of arbitration process, right? Now dispute resolution process are classified into two. One is consensual and amicable. That means you yourselves are accepting for arbitration and you are going for arbitration, getting the award, and it is binding on you. Ningala arbitration porango parties, they will go to arbitration, they will get the award, and it is binding. That means both the parties are accepting here by their consent. They are going right. Next in the arbitrator kittend notice varo. That means you have to go, and that is adversarial means it will adversely affect your rights whether you like it or not, right? One system first case rendu perkum bind agum, second case la othanuk favor avaro, that is going to affect the other person, non-adversarial. So here it is decided by trial, right? Trial by weighing the evidence and yes, legal arguments presented by the courts. It can be further distinguished as facilitative, advisory, determinative and combined or hybrid. ADR mechanism la nariya mechanism irukum, arbitration irukum, conciliation irukum, mediation irukum, settlements எல்லாம் கூட இருக்கும். இங்க ஒருத்தர் பாஸ் பண்ற அவார்டு மாத்திரம் பைண்ட் ஆகும், யாருன்னா ஆர்பிட்ரேட்டர். conciliator award pass பண்ண கூடாது. conciliator has no power to pass an award. mediator no power to pass an award. arbitrator கூட எங்க பவர் வரும்னா from your agreement. By your agreement you are giving the power to the arbitrator to pass an award. Once arbitrator passes an award, arbitrator award pass பண்ணிட்டா விட்டு ஆர்பிட்ரேட்டரோட ரோல் இருக்காது. இன்னும் இப்போ கோர்ட் டிகிரி அண்ட் ஜட்ஜ்மெண்ட் கொடுக்கும், கொடுத்தா விட்டு கூட கோர்ட்டுக்கு என்ன இருக்கும், பவர் இருக்கும். இங்க அப்படி கிடையாது. ஆர்பிட்ரேட்டர் அவார்டு பாஸ் பண்ணிட்டா விட்டு அந்த அவார்டு கரெக்டா இல்லையான்னு சொல்லி எங்க போனா கோர்ட்டுக்கு வரணும். ஆர்பிட்ரேட்டர் டோன்ட் ஹாவ் எனி பவர் once award is passed. The jurisdiction of the arbitrator comes to an end. You know the meaning of jurisdiction. So arbitrator powers எப்ப க்ளோஸ் ஆகும்னா அவார்டு பாஸ் பண்ணா விட்டு ஆர்பிட்ரேட்டருக்கு இன்னொன்னும் கிடையாது. If you feel that award is not in accordance with the law, சட்ட பிரகாரம் அவார்டு இல்லன்றப்ப எங்க போகணும், திருப்பியா சிவில் கோர்ட்டுக்கு வரணும். According section 30 you have to file the award with the civil courts. You can challenge the award only in the civil courts. The role of the arbitrator comes to an end. That's it. మీరు ఎంతవరకు పెట్టుకుంటారు అంటే ఆర్బిట్రేటర్ అవార్డు పాస్ చేసేంత వరకే. అది అవార్డు కరెక్టా కాదా ఎలా ఉంది అని వానికి సంబంధం లేదు. వాడు అవార్డు పాస్ చేసేస్తాడు, సింప్లీ he will go away. So there are different process. Determinative process. Here the dispute resolution practitioner means arbitrator evaluates the dispute. He will evaluate your dispute. For example, A is coming, B is coming. He is going to evaluate the dispute. A case enna, B case enna solli evaluate பண்ணுவா. He is going to evaluate the dispute, tell the law, எந்த law apply అవుతుంది, ఏ law apply అవుతుంది, and makes a determination. He will determine whether award should be in favor of A or award should be in favor of B. A is going to file claim statement, B is going to file defense statement, right? So he will make a determination. Example of determinative dispute process of arbitration, export determination and private judging. He will determine your dispute. ரெண்டு பேரும் dispute determine பண்ணி என்ன கொடுப்பாங்க, அவார்டு கொடுப்போம். He will give the award. This is first process. Second one is facilitative process. Second one facilitative. We will go here. ADR, that is one facilitative. We will go here. ADR, that means ADR neutral means one person is there. He is involved in the dispute. அவன் என்ன பண்ணுவான்னா he will identify the dispute. எதனால நீங்க என் கிட்டக்கு வந்தவங்கன்னு சொல்லி he will identify. He will give the options also. He will give the options, consider alternatives. He will give you the alternatives and makes an effort to reach an agreed settlement. He is not causing an award. Award கொடுக்கலாம். அவன் என்ன பண்றான்? இது ஆப்ஷன். சட்ட பிரகாரம் இது உனக்கு வரும். சோ இதெல்லாம் நீங்க அக்செப்ட் பண்ணீங்களா நீங்களே ஒரு அக்ரிமெண்ட்லோకి ఎంటర్ అయ్యి you can go. Simply he will facilitate. He is not going to determine the dispute. He will facilitate by assisting you to come to a conclusion. அவன் என்ன பண்ணுவான்னா அவார்ட் எல்லாம் பாஸ் பண்ண மாட்டான். ரெண்டு பேரை உட்கார வச்சு பேசி இது ஒரு ஆப்ஷன் இருக்கும், இது ஒரு சாய்ஸ் இருக்கும், நீங்க ரெண்டு பேர் அக்செப்ட் பண்ணா you can go with this process. He is not passing an award. He merely facilitates. Right. Next one, advisory process. Right. Here he is going to give advice. Facilitative பக்கத்துல உட்கார்ந்து எல்லாம் பண்ணி கொடுப்பான். Advisory process, he merely gives advice. That's it. Advice on what? Advice concerning the dispute, advice concerning the law, then advice concerning strength and weakness of the case. Right? ஒரு advice கொடுப்பான். இது law. இது உன் கேஸ் இருக்கு. So this is the strength of your case. This is the weakness of your case. Simply he will advise. Advisory process. Determinative process, facilitative process, advisory process. Again, he is not going to adjudicate your dispute. Simply ஒரு advice கொடுத்துட்டு உனக்கு acceptable ஆனா நீங்க ரெண்டு பேரு ஒரு செட்டில்மெண்ட்டுக்கு வந்து you can close the dispute. Right? This is advisory process. He merely provides advice to the parties about the facts of the dispute, the law, and in certain cases, strength and weakness of each parties and desirable outcomes also. இது மாதிரி போனா இது மாதிரி வரும்னு சொல்லி அவன் என்ன பண்ணுவான்னா ஒரு அட்வைஸ் கொடுப்பான். Advisory process includes appraisal, expert appraisal, case presentation, mini trial and early neutral evaluation. This is another type of process. It is also an area mechanism. Gopal, class practice kadiyadu. So you are getting sleep. Yeah, right. Yes. No. You can sleep in the class. It's your fundamental right. Under Article 21. Article 21. If I say don't sleep, you say, sir, you are violating my article, fundamental rights. 21. Ante kada? Theriyuma Article 21 enna theriyuma? Article 19 theriyuma? 14 theriyuma? Why I am telling you is, in Viva, external professor asked one person, right to freedom, which article? Can I get right to freedom? Which article? He asked the question. Na miniye sonna. Unaku doubt irundha, see my eyes. If you have any doubts, see my eyes. He saw me. Enna paatha. Na enna panna? 2 1. Evla idu? 21 சொல்லலான்னு I sign. He says 12. Right. அப்புறம் இப்படி மாத்தினா 300. He is telling 3. நான் என்ன பண்ணோம்? I am trying to help, just learn some basic articles. Right? Fundamental rights part 3, article 14, 19, 21. Right? You see my eyes, I am trying to help you, but grasp that what I am going to tell you. Yeah, please. Listen. இந்த மாதிரி நிறைய வரும் வைவால. So many people are coming this. I am trying to help. They are telling something different. Right? So, yes. Hybrid process. It's a combination of all. We will see. The dispute resolution practitioner plays multiple roles. For example, in conciliation conferencing, the dispute resolution practitioner may facilitate discussion as well as advise on the merits of the case. It's a combination of process. It is also known as med-arb, mediation and arbitration, hybrid. It is known as med-arb. Why I am telling this is one arena where you can practice in the arbitration conciliation side. So here there are various ADR techniques out there. You have to remember this: arbitration, mediation, conciliation, mediation, arbitration, mini trial, private judging, baseball, final offer arbitration, court annexed ADR, court annexed ADR and court Moolama arbitration, legal services authority, lok adalats, they are court annexed mechanisms and summary jury trial. Right. Now we are going to see the advantages of ADR. Court ku pogade ADR ku pona emeni advantages anedi we will see. It's a private process of dispute settlement. Private process. Court ku pogade you are accepting going before the arbitrator. First an advantage, private process. Second one is expeditious. Expeditious means very speed. Very speed. You are going to determine court ku pona 3 varsham, 4 varsham, 3-4 years it may happen. But when you are going before a private arbitrator, within 3 months, 4 months, you are getting the divine award. Third one is informal. That means if you go to the courts, courts are formal. They have to follow civil procedure. They have to follow Evidence Act. But arbitrator need not follow Evidence Act, need not follow CPC. But agreement lo meer raaskuntaru. You can write in the agreement whether it is applicable or not. It is enough if principles of natural justice is followed. Second one is inexpensive. So it's very inexpensive. Court ku pona nariya kaas selavikano, arbitration pona you need not pay the court fee also. Very cases level court fee 1 crore, 2 crores. But you are going before an arbitrator, you need not to pay court fee. Even parties can straight away go and argue the case in the arbitration. Parties could direct up arbitration la, you can argue the case. Lack of technicality, technical procedures anni chodaru. Court, if you go to the court, they will go according to the technical procedure prescribed under the statute or law. Here you are not going according to any technicalities, right? Simply they will go with the dispute, evidence, they will pass an award. Award is binding. Award is deemed to be a decree. Award vandu decree kadiyadu, but deemed to be a decree. Decree is always appealable. Terima, decree is always appealable. Award kuda appealable. Yeah. Award enna solluvaanga deemed decree. Decree kadiyadu, but in the eyes of the law, it is deemed to be decree. Next involves community participation, right? Decision making process is controlled by the parties. You can tell the arbitrator to resolve which disputes, right? Next one leads to amicable results. Relationship is secured. Finality of the resultant, confidentiality. Rights in rem or persona. Rights in rem or persona here. Arbitral award. Persona. Our court judgment கொடுத்தா எல்லாருக்கும் தெரியும். அது என்ன சொல்லுவாங்கன்னா ரைட்ஸ் இன் ரெம். ரைட்ஸ் இன் ரெம் இது வந்து ரைட்ஸ் இன் பர்சனா. இட்ஸ் ஏ கான்ஃபிடென்ஷியல் ரைட். Now we will see different types. Two broad categories. One வந்து court annexed options. Court annexed options. Through court you are coming to arbitration. Second one is private ADR mechanisms. Court annexed option anna first court ku poi you have to come to ADR. That means alternate dispute resolution. For example, divorce case. If you file a divorce case, first enga poganum theriyuma court ku poi da conciliation ku varanum. Direct ah neenga vandu arbitrator kitta pogalam divorce cases anna no mudiyadu. Criminal cases you cannot go before arbitrator. Ella case arbitrator kitta varakoodadu. There are certain issues are there. Some cases cannot go before the arbitrator. So arbitrator today falls into two broad categories. First in the court annexed options. Second, it includes mediation, conciliation, judicial settlement. You are going to the court. Court is referring you to go to arbitration. Court annexed options. Now, these methods decrease the cost and time of litigation, improving access to justice and reducing the court backlog. Right. Next one is private ADR. This is includes commercial arbitration, conciliation and mediation. இப்போ உங்களுக்கு two options இருக்கும். நீங்க arbitration போனோம்னா ஒரு private person கிட்டக்கு you can go for arbitration. You can go before a private person or institutions இருக்கும். Very cities commercial arbitration centers will be there. You can go and select that institution as your arbitrator. Either you select a private person or you can go before the institution. Two options இருக்கும். நீங்க இவரை select பண்ணிக்கலாம், அங்க select பண்ணிக்கலாம். If you are going to select an institution, again they will follow UN Citral Model Law, United Nations Commission on International Trade Law. Hyderabad, there is International Commercial Arbitration Center is there. Bangalore, it is there. You can go before a private arbitrator or you can select an institution. Right. So, more countries have passed legislation based on 1985 UN Citral Model Law on commercial arbitration. Right. Again, you can distinguish this into two types, whether it is binding on you or whether it is not binding on you. Award கொடுத்தா bind ஆகுமா இல்ல bind ஆகாதா? Arbitrator கொடுத்த award மாத்திரம் தான் bind ஆகும். இங்க ఏది కూడా మీ మీద binding nature అనేది ఉండదు. So various ADR process can also be distinguished from binding and non-binding character of their final results. Right? అది మీ మీద bind కాదు. So negotiation, mediation, conciliation or non-binding forms. Right? Now it depends upon will of the parties. It depends upon the will of the parties. நீங்க ஒத்துண்டா bind ஆகும், ஒத்துக்கலன்னா bind ஆகாது. But arbitrator கொடுத்த award மாத்திரம் whether you accept or not, it is binding. How it is binding? You are accepting that you will go before the arbitration. The award is binding on you. No, I can recognize your faces. Whoever is talking, I have God's gift is there for me. I can remember your names, your faces. What many days? Am I true or not? Yeah. I can see your faces. Why are you no. Ipo, whenever I am coming, so many people are, so many students are wishing me. Aduk minna terilla. Ipo why are you 1 month la? Right, sir. Huh? Right. If you don't know the question, look at my eyes. Right. But I don't look at your eyes. Simply I will look like this. Em Google, class paddam aravan phone chesinavanట నువ్వు రైట్ ఇప్పుడు కూడా వచ్చిన్నాడు 2000 రూపాయలు ఫైన్ కట్టాలి కదా అని చెప్పి ఆల్ ఆర్ యు హావ్ టు పే some 2000 rupees fine, otherwise happy, right? Scope and differences of major area process, right? In India, historically, the means by which disputes in the court system have been resolved other than by trial. Whenever you are going before an arbitrator, no trial will be there. You know the meaning of trial. Trial irukadinga. For example, under this common system, arbitration, mediation, conciliation, lok adalat, judicial settlements will be there. Main advantage of arbitration is no trial. Basing upon your evidences, they will adjudicate your disputes, right? Arbitration is a private adjudicatory process and the most popular among the available ADR methods in India, right? Now, once a dispute is referred to arbitration, the case will go outside the stream of litigation permanently. Uruvati arbitrator refer panna adu vandu court jurisdiction ఏమవుతుంది బయటికి వెళ్ళిపోతుంది. It will go out of the jurisdiction of the courts. Once a case is reoffered to arbitration, the case will go outside the mechanism. It is going outside the purview of the courts. Uruvati court refer panna court jurisdiction lende, it is going outside. Next one is mediation, conciliation. It is a facilitative negotiation process in which disputing parties engage the assistance of an impartial third party, the mediator, conciliator, who helps them to try to arrive at an agreed resolution of their disputes, right? Now we will see difference between mediation and conciliation. Governed by statute, mediation means Indian Contract Act, first one. That is the law which governing mediation. Which is the law governing conciliation? Arbitration and Conciliation Act. That is the law. Second one, nature of process, mediation, it is facilitative. In conciliation, it is evaluative. Role of the neutral. Passive means he is not actively taking part, he is more active. Whether neutral means arbitrator can propose settlement or proposal in mediation, no. Conciliation, yes. This is the difference between mediation and conciliation. Governing laws. ఏదన్నాళ్ళం కూడా ఒక చట్టం తీయరా you have to నీ పేరు మర్చిపోయినా నాకు నువ్వు ఎదురుపోతున్నావు నేను చూస్తాను ఇప్పుడు రైట్ నౌ దిస్ ఈస్ ది governing issues. Next, judicial settlement and lok adalats means a compromise entered by the parties with the assistance of the court adjudicating the matter or another judge to whom the court has referred the dispute. So lok adalats are governed by Legal Services Act 1987, District Legal Services Authority, State Legal Services Authority, National Legal Services Authority. These are the different area mechanisms. Now we are going to see Indian legislations pertaining to ADR, Indian legislation. Normally we are following UN Citral Model Law. Even before the Arbitration Conciliation Act, Arbitration Conciliation Act minna kuda nariya legislations unnai. We are going to see. So, first one is Code of Civil Procedure. Code of Civil Procedure also, there is one provision to refer the disputes to arbitration. Even before the enactment of Arbitration Conciliation Act, these are the acts. CPC la kuda or provision irukku. Family settlement vandappo neenga enga polanna arbitration you can go. First provision enacted in Code of Civil Procedure. Next one is the first Indian Arbitration Act was enacted in 1899, which has been replaced by Arbitration Act 1940. Even before 1996 also, Arbitration Act 1940 is there. That means you are having old act is there, you are having new act is there. The difference enna previous act judicial intervention is more. Judicial intervention anna two members are there, A and B are there. వాళ్ళు ఏం చేస్తారు, they go before arbitration. Arbitration போன உடனே Bக்கு வந்து arbitration பிடிக்கல, அவன் என்ன பண்ணுவான், சிவில் கோர்ட்டுக்கு போய் ஸ்டே கொண்டு வருவான். Arbitration proceedings ஸ்டாப் பண்ண சொல்லி. Previous actல ఏముంటుందంటే judicial intervention is more. That means at any point of time, any party can go to the court, obtain stay. Young old act la, new act la stay எல்லாம் கொடுக்க முடியாது. Only when courts can interfere means only after passing the award. Old act la என்னமோ எந்த பாயிண்ட் ஆனாலும் கோர்ட் இன்டர்ஃபியர் ஆகி ஸ்டே கொடுக்கும். நியூ ஆக்ட்ல ஸ்டே எல்லாம் கொடுக்க முடியாது. எப்போ நான் இன்டர்ஃபியர் ஆவேன் கோர்ட் சொல்லணும், அவார்டு கொடுத்தா விட்டு I will going to interfere. That means old act more judicial intervention is more. New act there is no judicial intervention. I will interfere only after the award has been passed. Right. Now Section 12 of the Industrial Disputes Act 1947, conciliator provision is there. 1947, even before enactment of the Arbitration and Conciliation Act. CPC la provision irukku, Industrial Disputes Act la kuda provision irukku. Next one the Section 23 of Hindu Marriage Act, there is one provision for conciliation. Once you file a divorce case, you can go before conciliation, right? Next one is Order 32A and Order 23 of the Code of Civil Procedure 1908. These are the previous legislations. Ippo kuda irukadu, still it is there. even after enactment of the new act also, you can go before the arbitration under these legislations. Industrial Disputes Act 1947 provides both for conciliation and arbitration for the purposes of settlement of disputes. Right? Yeah, please. Hindu Marriage Act, it is there. It casts a duty on the court before granting the divorce. The court shall first instance make an endeavor to bring about a conciliation. Divorce கொடுக்கிறதுக்கு முன்ன என்ன ஆகும்? Conciliationக்கு போகணும். You are what is called compulsorily you have to go before conciliation. Without conciliation, divorce cannot be granted. So, the court shall in the first instance make an endeavor to bring about reconciliation between the parties. Right? Now, civil procedure 32A lays down that provision relating to matters concerning the family settlement, they can go before the conciliation. Right? Different matters are there. Guardianship, custody of minor, maintenance, wills, succession, etc. So even before the enactment of the arbitration, these are the prevailing laws. Now another significant development is Lok Adalats. Legal Services Authorities Act 1987 recognized Lok Adalats are, you know, its people's court. This is a non-adversarial system where conciliatory courts are held by state authority, district authority, Supreme Court Legal Services Committee, High Court Legal Services Committee, Taluk Legal Services Committee. These are various mechanisms, right? So you know, you have understood the genesis of the Arbitration Conciliation Act. Different types untundi. Arbitration, mediation, conciliation, negotiation. So many. It is based on Arbitration Conciliation Act 1996, which is based on UN Citral Model Law. Different types: adversarial, non-adversarial, consensual, non-consensual, facilitative, determinative, adjudicative process. Indian legislations, we have seen Code of Civil Procedure, Family Act. Now we are having Lok Adalat under different authorities. Another important feature is no court fee. You need not pay court fee for arbitration. Court fee pay pandra தேவையில்லை. You need not pay court fee and no rigid procedural requirements. If you go to the court, strictly Civil Procedure Code will apply, right? Evidence Act will apply. Here it is not going to apply. There is no court fee and the rigid procedural requirements. No need to follow the process given by CPC or Evidence Act, which makes the process very fast. Right? A case can be transferred to Lok Adalat if one party applies to the court and if the court sees an opportunity to compromise. Right? Now, this arbitration or ADR mechanism, they don't have jurisdiction on non-compoundable offences. You know, cognizable, non-cognizable, yes. Then bailable, non-bailable, compoundable, non-compoundable. தெரியுமா டிஃபரன்ஸ்? என்ன non-compoundable அண்ணா? Punishment by non-compoundable. Huh? Cannot be Non-compoundable means you can pay the fine and come back. In the non-compoundable, pay the fine, go back to home. Compoundable. It's compoundable. Yes, non-compoundable means yes, it cannot be what is called, you cannot pay the fine. You have to go for the punishment. Right, compoundable offenses. So, this Lok Adalat, does not have jurisdiction with respect to non-compoundable offenses. Non-compound offenses kallam kuda jurisdiction kadayadu. Next. The focus in Lok Adalat is on compromise. When no compromise is reached, the matter goes back to the formal court. No compromise is reached, the matter goes back to the formal court. However, if a compromise is reached, an award is passed, award is final and cannot be appealed. Award final or appealable kadiyadu except on certain grounds. Very, very few grounds. Even Supreme Court don't have any jurisdiction to, yes, reverse the award. Right? Got something today? Edavadhu pocha mind la? Enna pocha? Very good. Nothing, sir. తీసిచ్చేవా அது எடுக்கணும் இல்ல க்ளோஸ் பண்ணி எடுக்கணும். థ్యాంక్స్ వాళ్ళండి. ஒன்றும் இல்லை, ஒன்று நிமிஷம்.
பிளக் பண்ணுங்களேன் அதெல்லாம். இல்ல திரும்ப தானே வைக்கணும். See, I wanted to open this drafting. First CPC barrack வேணும். அப்படி எப்படி கேக்குறீங்க? எது முதல்ல ஓபன் ஆகுது? CPC barrack. So can I actually do it? நான் கேக்குறேன். அது பாத்து க்ளோஸ் பண்ணவே இல்ல. நான் அப்படியே விட்டுறேன், மினிமைஸ் பண்ணிக்கிறேன். இது க்ளோஸ் பண்ணல. ஓகே. நெக்ஸ்ட் ஒரு செகண்ட். ஒரு நிமிஷம், நான் அடுத்த வேர்டு இதெல்லாம் ஓபன் பண்ணி வச்சிருந்தா இட் வில் பி ஈஸி. பட்
நான் இங்கே இருக்கேன். நான் இங்கே இருக்கேன்.
நீங்களா? Then I'll go down. Open this. போகாதா கீழே? ஓ அப்படியா, சரி சரி. Done. Done. ஓ
1 minute delay.
1 minute delay ஆகுமா? Good morning, everyone. Good morning. Please settle down. Now we are going into drafting. நேத்து நம்ம என்ன பார்த்தோம்? We had a general talk how to with regard to drafting, pleading and conveyancing. Before that, what is pleading? Pleading Anna, is it plain or written statement? Is it plain and written statement? Neither plain nor written statement. At the back, anybody from the back? யாருக்காவது பதில் சொல்ல முடியுமா? மனிஷ், மனிஷ், சொல்லுங்க. Pleading as per order 6, it is plain or written statement. Either it can be pleadings means written statement ஆவும் இருக்கலாம் or plain ஆவும் இருக்கலாம். Now, நேத்து அது சொல்ல விட்டு போச்சு, that's why I want to add it. Now we are going to draft what is how to draft the legal notice. So if there is any litigation or if there is any breach in contract or breach in performance of a contract, the first thing the party does is how will intimate the other party, the defaulter, that he has committed some kind of default. So other number through an advocate, how do you send a legal notice is what we are going to learn today. People, this is the format of how you have to draft a legal notice. So while you draft a legal notice, the head note has to be the name of the advocate and the address to which he is sending, from which address he is sending the legal notice. Why is it mandatory? Because if the person, the defaulter, நம்ம யாருக்கு letter அனுப்புறோமோ, that person had to respond, had to give his reply notice, right? So in order him to send the reply notice to have a proper service of the notice, we have to give the detailed address of the pleader or the advocate. So first is the name of the advocate and the address. Second, what is the second most important thing? The date in which you are sending the notice. Date is also mandatory. As I told you in the last class, if suppose, for example, number 138 notice anuprona, it is mandatory that on the default in the 30 days to full number notice anupro. 138 NI Act, remember? If a check is being bounced by way of insufficient of funds or some other matter, that is by stoppage, fund is transferred பண்ணமுடியா stoppage பண்ணிருக்காங்க. இல்லனா if it is insufficient of fund, then you have to intimate the other person defaulter within 30 days from the date of default, right? So on the 30 days குள்ள நம்ம notice அனுப்புறதுக்கு நம்ம அதுக்குள்ள தான் அனுப்பியிருக்கோம் காமிக்கிறதுக்காக it is mandatory that you have to mention the date in which you are sending the notice. Clear? Next, to whom you are sending, the person's name and address has to be clearly mentioned, or his designation. If it is a firm, you have sending in the name of the what is the designated officer, the head office, head office, all these things have to be there. Then what you have to mention, the subject. Subject, na, in short, what is the relief or what is the thing you are alleging against the other person must be mentioned in a short form. That is repayment of money so and so. That much is more than enough. No need to go into depth in writing the subject. That's the notice done clear. Just a notice more than enough. Just the subject. Then what comes what? That is a salutation. Salutation would be respected sir, dear sir, madam, whatever it is, salutation depending upon it. Clear. Then comes what? An important sentence. That is, you are sending notice to the opposite party by only under the instruction given by your client. So you have to mention under the instruction from my client so and so. You have to mention that person's name, address and everything. You have to do a full description there also. Address of the person, of the name of the client, and under the instruction of the client, I am sending the above said, below said notice to you. Then you have to come to the body. Body gives you the details with regard to how you are entered into the contracts, what was the dispute with them, and how they had made that default in the payment or default in performance of the contracts. That has to be mentioned in short form. While you send a legal notice also, you need not mention the evidence there also. Now in the bank in the Brazil I have present money, in the not present money, bounce and the bank slip, all those things need not be mentioned. That you owe so much of money and you have made a default, you have promised to perform the contract on a specified date. After repeatedly demanding you to perform the same, you have not performed the contract. So I call upon you to perform the said contract within a stipulated time period. Default in which what legal actions will be taken against you. So a legal notice is sent by an advocate on behalf of the client. As per the instruction of the client, a legal notice is being sent to the opposite party. Now, what is the last thing I have to mention? The date on which you send the notice and the signature of the advocate. This is how you wind up the notice. Okay. Therefore, I humbly, not humbly, what is it? Therefore, I call upon you to pay the sum of money with interest, so and so. Whatever the relief you are seeking for must be asked, and also giving him a time period for him to respond. Whether it is 15 days, 10 days, 7 days, whatever it is, giving him a relaxing period so that he can respond, or else he can give the reply notice, or else he can perform the defaulting promise. So, this is our notice. This is the format of a notice. Clear. So that first one is the head note. You have to mention the advocate's address, advocate's name, then the date in which you are sending the notice, then to whom you are sending the notice, then subject. Notice then the salutation, then comes the content. Then comes the address of your client, your details of the client. Then comes the what is the body, what is the cause of action as arising. Also the remedy that you are seeking for, that is you have to repay the amount within the stipulated time period and the name and sign of the advocate. More than enough. Now, this is your client. So how do you frame the reply notice? Now a person has sent a notice to your client. See the notice to your client is one mission. Now how do you send a reply notice to the other person? Exactly. You can either admit the client. You can admit the client. You can seek further time for the performance. You can seek time to admitting client means it will be like Section 18 Limitation Act program. It will be running, so it's no problem. Then you can admit the client, or you can totally deny the client, or you can say that you have partly performed. Whatever, depending upon your contentions, you can frame. This is the same format for framing a reply notice as well. The only difference it would be is that for a reference also would be written. I will show you that. See, in reply notice, same way, either you can send it to the advocate who has sent the reply notice, or to the person or the client of the advocate to the reply notice. So if it is sent to the advocate, first வந்து நம்ம உங்களோட clientோட advocate பேரு address, then the date in which you are sending the address, because you have mentioned within 15 days you have to send the reply notice. So date of the advocate, the date in which you are sending the notice is important. Then comes to whom you are sending. Is it to the advocate or to the client? Then you have to give reference. That is, you are referring to what notice you are giving the reply. This is actually another reply notice not connected with the above reply. Above legal notice is another format. What is the reference? To reply notice dated on so and so. And the notice and the knowledge that date has to be mentioned, and other reference reply even. Then you have to give salutation under the inspection of my client so and so. I'm sending the notice to you. Then you can admit, you can totally reject, partly admit. All those things can be mentioned, and also sign of the advocate. This is the format for drafting the notice as well as legal notice. Now, once a legal notice is being given to the other person, reply notice is being given or not given, what is the next step that has to be taken by the aggrieved party? Instituting a suit. Now, who institute the suit? Plaintiff institute the suit, and institute is being represented by whom? The plaintiff is being represented by whom? Advocate or a pleader. Either the person can appear himself, or if he is able to afford an advocate or a pleader, he can do so. Now, under what provision of CPC gives you the right to appoint a pleader? எல்லாருமே advocate கிட்ட நம்ம advocate வந்து நம்ம போய் approach பண்றோம். And the advocate, from there, this advocate gets the power to represent the client before a court of law. Have you ever thought about it? Order 7 Rule 1 says about institution of a plaintiff. I am asking, who gives you the authority to the pleader or the advocates to appear on behalf of the client or the plaintiff or the defendant? This law. It is there in CPC itself. Order 3 deals about, Order 3 Rule 4 says about appointment of a pleader. Here, I will show you that. 1 second. Order 3 says about recognized agents and pleaders. Recognized agents are that is, sometimes if the plaintiff is not available in town, he can appoint a power of attorney. Or a principal power agent appointment, authorized agents can be there, right? But under Rule 4 says about the appointment of a pleader. Actually, by way of Order 3, Rule 4 gives the power to the pleader to represent the client in front of a court. Okay, please look on to the board, PPT please. Appointment of pleader under Order 3, Rule 4. No pleader shall act for any person in any court unless he has been appointed for the purpose of such person by a document in writing signed by such person or by his recognized agent or by some other person duly authorized by or under a power of attorney to make such appointment. Now, what is that piece of paper? And the writing in the paper appear now. Exactly. Vakalam. That is called that வக்காலத்துக்கு வந்து every court, like every state ஒரு civil rules of practice இருக்கு. And as per every civil rules of practice, the form would be different from state to state, but the content would be the same. Now, order 3 rule 4 prakaram, when a client gives in the authority, be it the client or be it the recognized agent, or be it power of attorney holder, he gives an authority to the other person or the pleader, then only he has a right to appear before the court on behalf of the aggrieved person or the plaintiff. Other than that, he shall not, whatever the person, இப்ப வக்காலத் இல்லாம ஒருத்தர் வந்து ரெப்ரசென்ட் பண்ணாங்கன்னா, it will not be, that pleadings won't be taken by the court. So the person either he himself can appear before the court and contest by himself or as recognized agents or power of attorney holders, or else he can appoint a pleader under Rule 4 of Order 3 by writing. It shall be in writing. Now, until then, this order or in the bond எத்தனை நாளைக்கு வர அவங்களுக்குள்ள இருக்கும்? That is, until then, can this person represent the client? There are it is mentioned in sub-rule 2. Every such appointment shall be filed in court and shall, for the purpose of sub-rule 1, be deemed to be forced until determined with the leave of the court. Leave of the court, na? Leave of the court artham enna? Permission of the court. Leave of the court means permission of the court oda namakku vena decline pannikalam, or else by signed by the pleader, as in the case may be, or until the pleader or the party dies. Yara ஒருத்தர் இறந்து போயிட்டாங்கனாலும் obviously they cannot be represented, or until the proceedings of the suit has been ended. In these 3 circumstances, under 3 circumstances, the file panna vakalat irukla, the writing that is being signed by the person shall be in existence. That is, until the case is being disposed of, until the either party, the plaintiff or the pleader dies, or with the leave of the court. Adha நம்ம relinquish பண்ணுவோம்னு சொல்லுவாங்க. வக்காலத் relinquish பண்ணலாம்னு. That is, relinquish means you are freeing yourself from representing the other person again furthermore. That is what relinquish means. வக்காலத் release பண்ணிக்கிட்டு இன்னொருத்தருக்கு வக்காலத் எடுத்துக்கலாம். Okay, so order 3 rule 4 gives you the authority to appoint the pleader. Okay, now it further states about what all and what not the pleader can do or cannot do. Just read this order key. Through advocate, you have to send the notice, reply notice. Got it? No advocate in time, he can approach the person as well in person. He can send himself. You asked me what was shown earlier, right? It was shown like it was sent by an advocate only, or is the person himself can send a reply notice. Then, now I will show you like from Andhra Pradesh High Court rules. There's a format rule number 12, I guess. The form of a wakalat and also High Court let it download panna format of wakalat will be shown like. So this is how wakalat would be like. Okay, that is the claim of the court. Next speaker. Yeah, I have done that. I maximize it. Takes time to reload. So is it clear at the back? So first thing with the wakalat form irukum, adu or legal paper size la irukum. Legal paper size you don't know, right? And name of the court. Standardized thing you have to fill in all the things. The name of the court, case type, whether it is OS, OP, CMA, or whatever, OPMA, whatever it is that you have to fill in. Appeal suit and appeal suitor, all those things have to be mentioned. The case number won't be mentioned then and there. Later only it will be mentioned. And also the year in which you are filing the wakalat. Then comes the name of the parties. Yaar neenga represent pandringa, who versus who is the case, and the details has to be mentioned. A copy of this would be circulated to you, don't worry. Because you will be given a record, and the record, because this is actually in the format that you have to write a record, you will be given 3 records. One is for ADR, one is for Moot and court observances, and other is for drafting, pleading, and conveyancing. So that would be in 3 parts. First part would be drafting, pleading, and also last part would be conveyancing. Conveyancing, you will have different types like sale, gift deed, mortgage deed, all those things will be there. Format for that. And also civil and criminal pleadings and drafting would be there in the first part. So first part, the civil part would be there, and other the legal notice. Second would be the reply notice. That is a format that was already being shown to you. A copy of that also would be served to you. Okay. Now this is the format of wakalat. Yep. In this, once you have signed in a wakalat, whatever it is mentioned there, you are giving the authority in writing to the pleader to represent you, to do any act on behalf of you, to file any petition on behalf. Each and every time he need not file the wakalat. Either way, it's more than enough until the case has been disposed, until the other party dies, or until he takes the leave of the court. Till then, you have the authority to perform on behalf of the parties, be it the plaintiff or the defendant. That is what I just told you. Until the leave of the court, you can get relinquished. Relinquish means, suppose if I am your client, you are not satisfied with my work, you can approach me, then and then I would relinquish my wakalat and give you back all the files to you. Now, with the relinquish letter order, you have to file a fresh wakalat. That is some other advocate you can engage. Huh? That relinquishment means I have no objection for you to engage in another advocate. I am voluntarily relinquishing and giving it. So I have to, it is my duty to whatever files I have, whatever details I have in your case, it is my duty to give it back to you. Now you can, while you file the fresh wakalat, you have to file a relinquishment letter also. Now, please pay attention. This is the form under Civil Rules of Practice, form number 12. Form number 12 says about the format of a wakalat. That what I showed earlier is from the High Court format, and this is the Civil Rules of Practice. Other British rules of format is this. Now, I do hereby appoint and retain to appear for me in the above original. There was another court or name, whatever the case type, parties or a type. Now, this is the content that would be signed, and it should be signed by witnesses as well. Okay. I do hereby appoint and retain to appear for me in the above whatever petition it is, to conduct and prosecute the same and all proceedings that may be taken in respect of any application for execution of any decree for any order passed therein. I empower any vakil to appear in all miscellaneous proceedings in the above suit or matter till and the decrees or orders are fully satisfied or adjusted, and to obtain the return of documents and to draw any monies that might be payable to me and in the suit or matter, and I do further empower my vakil to accept on my behalf services of notice and of any of my appeal or petitions filed by Court of Appeal, reference or revision with regard to the said suit and the matter before the disposal of the suit in the Honorable Court. Accepted. It should be accepted and has to be signed by any number of advocates. Advocates எத்தனை பேர் ஆகுது? Advocate sign பண்ணும்போது two things have to be there. Your signature, the name, your signature, your seal. Seal இல்லைன்னா at least உங்களோட enrollment number, dash bar, number bar, ஒரு number கிடைக்கும். Once you enroll, that உங்களுக்கு enrollment number கிடைக்கும். Enrollment number, membership இல்ல, enrollment number ஒண்ணு. நீங்க enroll பண்ணுவீங்கல்ல, அப்போ you will get an enrollment number. That enrollment number has to be there. And it has to be first sign பண்ணணும், then accepted ன்னு சொல்லி sign பண்ணணும். And parties must sign. And இதுக்கான stamp duty, all those things has to be fixed and also has to be filed. Okay. வக்காலத் clear-ஆ? So இப்போ உங்களுக்கு allegation என்ன இருக்குன்னா, first step is you are filing a legal notice. In reply, they will file a reply notice. Okay. And after the reply notice is filed, you are not being satisfied, then you can approach the court of law. Directly approach பண்ணாம, you can approach by way of a pleader. As per Order 3, Rule 4, you have the authority to appoint the pleader. Now this pleader has what all authority? என்ன authority ல அவர் நம்ம appear பண்றாங்க? That is, you are giving this document in the form of writing called the vakalat, so that மேல சொல்லிருக்க எல்லா விஷயங்களும் you can appear, you can contest, you can file petitions, you can receive petitions, you can receive money, you can receive documents, whatever in connection with the case, petitions, appeal, revision, review, whatever it is, அது எல்லாமே appear பண்றதுக்கும் and on their behalf they can contest சொல்லி கொடுக்கிற நம்ம authority தான் வக்காலத். Okay. வக்காலத் இல்லாம first நம்ம கோர்ட்ல ஃபைல் பண்ண இம்பார்ட்டன்ட் ஆன விஷயம் தான் வக்காலத். Unless and until you don't file a வக்காலத், you cannot represent your client. Now, clear? So far it is clear? Now the basic thing. What is a docket? Docket என்ன? Whenever you are filing a petition, irrespective of whatever it is, you have to file it in a docket. Docket la nama file pannom. Docket would be it would be the piece of paper actually covering the main petition. Understood? Like, say for example, this is the plaint. The plaint இருக்குன்னு நினைச்சுக்கோங்களேன். In the plaint cover பண்ணி there would be another paper called the docket. Now what are the materials or the particulars that have to be there in a docket? Docket இது பார்க்கும்போதே it is the first intimation what is this document is about. Would be the name of the court. Second, what case it is? It is the case number has to be mentioned. OSOP, whatever it is. Then, the parties, plaintiff, defendant, petitioner, respondent, whoever, appellant, respondent. Yaar in the parties in the capacity that has to be there. Now, what is the material here? It could be a plaint, it could be a written statement, it could be an interlocutory application, it could be an absent petition, it could be enlargement of time, it could be any. So, அது in the petition, in the plaint, எந்த orderல நம்ம file பண்ணிருக்கோம்? இல்ல what is it that is plaint filed under order 7 with section 26 of CPC, or petition filed under order 38 rule 5 attachment petition filed and ordered the case rule filed. So what petition is this? We shouldn't be confused whatever it is. Suppose if you are filing an interlocutory application. Now, name of the court, IA number dash, if OS number dash has to be mentioned. IA number has to be mentioned. IA number means what? Interlocutory application number dash of 2000 blah blah blah. Then OS number, those things has to be mentioned if it is an interlocutory application. Then the name. If it is a plain, what is it? If it is a plain, then if you are filing any suit valuation for cost, the court fees and control now. That court fees, fees number control, that fees also has to be mentioned. On what basis you are filing the fees? The fees the court fees that has to be mentioned. But this goes for everything. For wakalat, for playing, everything there should be a docket. Front page has to be there. Then, on behalf of whom you are filing? Advocate on behalf of the plaintiff. The name of the advocate has to be there. Then it's seal. Mr. X, enrollment number, seal. Has to be there. Then filed on which date? That is also important. In the nalla number file petition file. Say for example, if a notice and return, the court says you have to file the petition claims within 7 days. Order 9 rule 9, right? Order 7 rule 9. Order 7 rule 9 now you have to mention the code that you have filed within the specified date. So filing date has also must be mentioned. If a continuous process la nadakra vishayathu kedaila number petition file pannona, next hearing date also must be mentioned. Okay. All those details have to be there in the docket. Clear? Docket for every petition when you file before court of law, you have to file it in the docket. Now docket எப்படி file பண்ணுவாங்க? Petition இருக்குன்னா அது வந்து இங்க stitch பண்ணி petition stitch பண்ணி தான் they file and these are all mentioned in the rules. நம்ம சும்மா அது நம்ம யாரோ பண்ணான்னு சொல்லி நம்ம பண்ணது கிடையாது. This is all mentioned in the rules. Respective states the rules pass it. It will be difficult because many people are coming from different states. Difficult for me to mention one particular state. So you just go through the rules of your state concern and understand. And these are the formats for a docket. நம்ம கேஸ் ஃபைல் மென்ஷன் பண்ணும்போது when you what is it ஒரு கேஸ் ஃபைல் நம்ம மெயின்டைன் பண்ணும்போது at your office also there is a docket name of the court. What is the difference in that is that in that docket you have to mention the next oral posting என்னெல்லாம் ஸ்டேஜ்ல இருக்கு. What is the next posting date is posted for? Is it for hearing? Is it for trial? Is it for PTS? Is it for evidence? Or is it for production of documents? Or is it for a commission report? Is it for appearance of parties? All those things have to be mentioned. அடுத்த நாள் அடுத்த போஸ்டிங் எதுக்காக இருக்குன்னு பார்க்கிறதுக்காக to make your work easy. You have to mention the docket. You have to mention in the case file also. Now you know the difference between A diary and B diary. Now, once the court proceedings as winded up for the day, you know the roll call and these are all the things that you have to observe when you go for court observation. Roll call is the first list of cases, like list of cases that will be called for the day. In every court, I don't know how it is done here, in my place, they would put a list in front of the court. Court care, they will put exhibit the list. In which order the case would be called, whether it's EP first, OS first, IA first, final degree application, in the order that is called the roll call. Okay. Now once the court when it's summons, what happens? As per the roll call, the court will call the cases. The court officer, you know how the court will be set up? The judge or the judge would be there, the court officers would be there, case bundles will be kept here. Now one of the court officer would stand up and call the case number. That அந்த எந்த ஆர்டர்ல கூப்பிடுறாங்க சொல்றது கிளியர் ஆகுறது தான் roll call. Now in the roll call முடிஞ்சு, now if the case is for evidence or if it needs some clarification, the court will take it further after the sessions of the roll call. The court will take it in detail அதுக்காக மாத்தி வைப்பாங்க. Now after 3 o'clock, 4 o'clock when the court winds up, the court officers would take the details for what the case is posted for. இன்னைக்கு இப்போ என் case OS number 10/2020 போட்டிருக்காங்க. This is what evidence. Now the court has written for cross examination. This would be mentioned in the diary called a diary. It will be maintained in the court with correct date. In the date, the OS number 2 bar blah 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 was told. It is posted on so and so date for cross examination. As a junior advocate, when you join a court office, you join பண்ணீங்கன்னா, please make sure you have the habit of going to the court and asking உங்களோட case or next posting எதுக்காக? What it is posted for, and when it is posted for, that you have to be known. Then you have to come back to your office. That normally this is work done by the clerk, but you also are free to do it. Come back to the court and enter it in your register quality right. Okay. What is meant? Upon we can have an up to date. What is it? Case எதுக்காக post பண்ணிருக்காங்க? All those things you will be verified, and in any circumstances. Suppose if you are, why is it important I'm saying is, if you fail to get the date and if you don't appear before the court, what will happen? You are a plaintiff. You are supposed to appear on 10th of March. Now, being the correct date book enter பண்ணாதனால, you are not able to appear before the court on 10th of March. Now, court the case கூப்பிடுவாங்க. Now the court will call upon the case, and there is no parties as well as no pleaders appearing on behalf or for the case. Now what will happen in the case? The case would be dismissed. Now if it is a defendant, what would happen in the case? He would be set ex parte, which will cause serious injury to the parties' rights. Being an advocate, please don't do such a thing. You should be vigilant. Because உங்களோட அவங்க பேஜ் உங்க கையில தான் இருக்கு. Suppose if the court was so adamant that he would not restore the petition or he would not set aside ex parte, then your client would be really affected. So date எப்பவுமே நம்ம கோர்ட்ல போய் எடுக்கிற date, even if the court allows the next adjourned date சொல்லும்போது கூட you have to be vigilant and take down the date. Next evening, every evening it will be ready. In every court, every evening the next posting date would be ready. Sometimes அடுத்த நாளைக்கு post பண்ணிட்டாங்க. What would you might not know. So before you leave your office, while if you are practicing, before you leave your office, go to the court and just find out when it is being posted for. Maybe இப்போ ஒரு bail கூட கொடுத்தாங்கன்னா, criminal case, bail in the what is the condition that was applied, bail கிடைச்சிருந்து happy நம்ம வரக்கூடாது. Court might what is it, say some conditions that you have to do to 550. சீக்கிரம் நிப்பாட்டு போறது. Next class, you will be shown a format of claim, written statements, interrogatory allegations. And an appeal. If possible, I'll show you an appeal format also. Then next class is going on with it. Please don't leave the class, please stay seated. Huh? Was it clear today? Now that madam is standing outside, I thought she'll be done. Students, please be seated. We will have next class will be commencing in 2 minutes. So please be seated. Please come back. Please be seated. Your next class will begin soon. Please. On లో ఉందా? Yes. Hello. మీరు అనుకున్న హలో కాదు ఈ హలో. వస్తుంది. సరే. Shall we start? Thank you. We will continue yesterday's session. Huh? Yesterday's argument, huh? Sorry. Anyway. So, what are all the duties of an advocate? Duty towards the court. So you have understood what are the duties of you after becoming an advocate towards the court. Next, duties towards your client. Next, duty towards the opponent, opposite side, opposite party. What are the duties? There we need to start, right? We have to continue from it. Yes. Duty towards the opponent, duty towards the opposite party. What do you expect? Here, in this situation, you presume yourself as the other side, opposite party. Okay, so you are party to the dispute, and what do you expect from the other side advocate? Is my question. The same things. Do. Can you explain one? Due respect to the opposite side. Okay. ఇక్కడ కూర్చున్నావా శర్మ? We should not negotiate. an absolute no to the condition that negotiation can take place with the opposite party without the consent. Without the consent. With consent, okay. Outside the court settlement okay. So without the consent, should not have any sort of interaction, discussion. No threaten. You cannot threaten the opposite party, opposite side advocate or whoever it is. Very good. To obey the Indian Constitution. I didn't expect this sort of answer. Obeying the Indian Constitution. Were you absent yesterday? Make you expect Pandit Rampo. Advocate has to obey. This is what we are discussing, and the professional ethics is all about. Okay. Not to prolong the case. Very good. Not to prolong the case. Inka. Chaka రాసేసుకుంటున్నారు. ఇంకా what else? Mislead the opponent. Can you make false promise? No. That amounts to misleading, huh? Whether misleading is equal to false promise, making false promise, false assurance. Right to have a copy. Copy of what? Status of the case. From date of filing to the present. Status of the case. Okay. Inka? So, you have said all the 3 points here. Very good. So, duty of an advocate towards the opposite. You can note down these points because you need not prepare again. Ready answer for you. But you are not supposed to take photo. Don't be lazy, okay? So, coming to the next one, duty towards your colleagues. Colleague here is your colleague friends, other advocates, who may or may not be a opponent. Other advocates. So how do you behave with them? With fellowship. Fellowship is one thing which you have seen in lambs of advocacy. That is one of the lambs of advocacy, fellowship. In our previous classes we have discussed. So what do you mean by fellowship? A cordial relationship. It is your duty to establish a cordial relationship. You must not go for any sort of complex or ego clash. Untundi kachidanga untundi, but you should not show it. That makes you a professional. If you go against this rule, then there are chances of becoming an unprofessional. You may get a tag of an unprofessional lawyer. So, coming to the duties. Shall not solicit the work or advertise. The concept of advertise, the rule of advertise, we have seen in our previous class. Whether an advocate is permitted to advertise his capabilities, is it permitted through social media also? Yes. No. No. Yes. Can you support your answer? Ah.
Then we should not explicitly in the society that he is efficient, this, that, and all. It will like mislead and it will like what the other advocate will get the equal up. And also you will reserve that what the soliciting the client.
Ah. It is a professional misconduct.
The close friend.
By oral propagation, you can solicit a client. Huh? But we have every day we are seeing in social media and Instagrams. Avna? Advocates. Huh? One by one. Immediately advertise చేయొచ్చు. So this right is subject to certain restriction. This is what you mean to say. Avna? Can advertise, can solicit a client, but subject to a restriction. The other party's right gets violated and oka presumption to na can advertise or no? No, cannot advertise. Anyone from girls side? By this time you might have read this condition, duty. An advocate shall not solicit work or advertise either directly or indirectly, whether by circulars or by way of advertisements or through touts. Who is a tout? TOUT. Just like an agent. Just like an agent. పెంచుకొని వస్తారు. For example, if you are asked for a placement in a firm, you will be referred to a firm through an agent. So, ఆ ఒక ఫర్మ్ లో మీకు ప్లేస్మెంట్ రావాలి అంటే ఎవరి మూల్యంగానో మీకు వస్తుంది. There are people who are occupied in this area. వాళ్ళకి ఇంత కమిషన్ అనేది వచ్చేస్తుంది. Either from an advocate or from the firm and sometimes from you people. And either by way of personal communication, furnishing or inspiring through a newspaper, comment or producing his photograph to be published in connection with a case in which he has been engaged or concerned. Now explain me what this duty means. This is a very exhaustive duty. Everything is included in it. But if you read the last sentence, what it means. In which he has been engaged. ఏ కేసులో అయితే ఎంగేజ్ అయి ఉన్నాడో దాని గురించి చెయ్యకూడదు, దాని గురించి చెప్పకూడదు. Other general things can be, other legal issues can be discussed. Next, he must maintain a respectful and cordial relationship. This is what we discussed just now with a fellow advocate. And next comes the other duties. What are the other duties of an advocate? Other duties. General duties. Number 1, every advocate on roll must pay the fee. Advocate's fee అనేది చేయాలి. అవునా? Subscription కట్టు ఉండాలి. Yearly membership. Yearly or life member. Okay. Yes to the bar council. And the amount which is collected is credited to Bar Council of India Advocates Welfare Fund for the state, that particular state. And the fund is used for certain emergencies, to attend emergencies for the development schemes of an advocate or so, the whole class. And duty not to demand, receive, accept any fee for imparting training in law. Training in law. You are an advocate. You cannot demand a fee. You are invited for a guest lecture. An advocate is invited for a guest lecture. Can he demand money for imparting the practical aspects of profession to you? No. Can receive. Honorary. Please coach. Please coach. See, whatever we are studying theoretically differs in practice. A total difference we can see. And next, duty to render legal aid. It is the duty of an advocate to render legal aid whenever a person approaches. It is your bounden duty. Which article of Indian Constitution? Constitution, sir. Which article provides for free legal aid? 20? 21. Which article? 39A na, 29A na, 21 na, 24 na? Which article? 39? 39A. Huh? Duty of the advocate. Duty of an advocate. Duty of? Duty of an advocate to render legal service, to give advice, legal advice. There lies an opposite right, right of a person. So whenever a public or a person approaches you, how do you react? Will you expect fee? Expect acceptance level. Will you expect fee from him for legal advice? Yes. A very frank answer, yes. I appreciate. There are people who do not accept any sort of fee for just advice, legal advice. But the number is more who is accepting money. Less number with free legal aid. And next comes duty not to engage in any business personally. This is already we have seen. He cannot be a managing director, an active partner in a company, can be a sleeping partner. What is the difference between sleeping partner and active? Just for namesake. Just for namesake, he occupies the post. Doesn't have any vote, yes. And so, this is all about the other duties. Now, my question for you is, many of you are involved in writing an article and getting it published. Yes? And when you are called for a recommendation relating to an act, a legislation, parliamentary proceedings, you are invited to. You have been asked for certain recommendations, your suggestions and all. You will get payment. As an advocate, you may receive a payment. Within brackets. That was in practice. Apprentice అనేది practice లో ఉండింది, but later on apprenticeship అనేది తీసేస్తున్నారు. Now again they are making it, that is they have recommended for against starting this apprenticeship. Apprenticeship is different. Internship. This is what? Internship, apprenticeship. Law అయిన తర్వాత internship ఎప్పటి నుంచో ఉంది. Yes, it is in practice since long time. ఎక్కడ ఇది లేదు. Students వెళ్తూ ఉన్నారు. Internship వెళ్తూ ఉన్నారు. During their course, they have joined. Judge office అంతా join అయ్యి వెళ్తూ ఉన్నారు. And I am talking about apprenticeship. After completion of your course, apprentice అనేది వస్తుంది. Just like a junior, you will be paid stipend, monthly stipend ఎంత ఇస్తారు. Okay, so an advocate may review parliamentary bills for remuneration. It is not, or it doesn't amount to professional misconduct. You are entitled to such remuneration. That is your privilege here. And next, you can edit legal textbooks at a salary. Do press vetting for newspapers. What is this press vetting? Note down this press vetting. అన్ని స్పూన్ ఫిట్ చేస్తుంటే కష్టం కదా. What do you mean by press vetting? And an advocate can coach people for the one who is preparing for judicial exams. He may charge fee from the students. That is not forbidden. He can charge. He can charge. And so, what's time now? What's time now? So, these are all the duties of an advocate, different duties, and this will be asked in your exam. And next comes professional misconduct. Professional misconduct. What do you mean by? See, all the duties, if you have knowledge of these duties, failure of this leads to, makes you an unprofessional. Makes you an unprofessional. So, duties and conduct are interlinked. What do you mean by professional misconduct? What are the instances of professional misconduct? When can we say an advocate is guilty of this misconduct, professional misconduct? What is the action that can be taken against an advocate who is unprofessional? And what are the remedies that are available to the advocate who is accused of misconduct, professional misconduct? Here, the Advocates Act do not define the term misconduct, professional misconduct. What constitutes misconduct? So, taking into situations, different situations, and the actions of a professional and the actions of those professionals which are considered unethical, and they act against their duties, prescribed duties, we call them as unprofessionals. అంతేనా? చేయాల్సిన పని చేయకపోయినా, చేయకూడని పని చేసినా, that amounts to misconduct. The Supreme Court in a case held this misconduct can be a breach. What do you mean by breach? Violation. Huh? Not to do. Not to do. ఏదైతే చేయగలమో అది చేయకపోయినా, చేయాల్సింది చేయకూడనిది చేసినా అది బ్రీచ్. బ్రీచ్ ఆఫ్ డిసిప్లిన్, wrongful omission or commission. Wrongful omission or commission. Either intentionally or unintentionally. So, intention do not have much role to play here. Whether done or omitted to be done, intentionally or unintentionally. With improper behavior, deliberate violation of a rule set by an authority, can be considered as misconduct, a professional misconduct. So we will see what are all the instances of, few instances, I have selected few instances of professional misconduct, and all these instances, as they are very general in nature, you might have heard earlier also. Number 1, be attentive. The second half of the auditorium. The instances are making false allegation against judicial officers. Is it a professional misconduct or no? Yes. All the instances are very simple in language. So by giving a reading, you can understand what it is. Number 2, attempting to influence judicial officers for favor. That is a misconduct. You cannot. So violation of duty leads to misconduct. Makes you land as an unprofessional. Next, carrying on other trade or business. Full-time trade practice undakudadu. Next, obtaining client's signature on blank papers. Is it required for an advocate to get signatures? Sometimes it is required. And even a client can sign in blank paper only when he has trust, faith in advocate's capability. కొంచెం డౌట్ ఉంది అంటే క్లయింట్ కూడా తప్పుగా సంతకం పెట్టి వదిలేస్తాడు. అతని యొక్క సంతకం కాకుండా, రెగ్యులర్ సైన్ కాకుండా వేరే విధంగా కూడా పెట్టి వదిలేసే సిచ్యువేషన్స్ ఉన్నాయి. నెక్స్ట్, tampering with the records, documents and witnesses. It amounts to misconduct, professional misconduct. You are not supposed to tamper all the evidences and all. Next, failure to appear in the proceedings of a case without sufficient reason. Failure to appear. When you accept a case, when you as an advocate accept a case, it is your duty to appear for each and every call. అవునా? నాకు లేదు, నేను బిజీగా ఉన్నాను, ఇంకొకరు వస్తారు అంటే no. If this continues, if it is a habit for an advocate to abstain or becoming absent to appear before the judge with regard to that particular case, then that can be considered a misconduct, professional misconduct. Next, misappropriation of decreed amount. Misappropriation, swaha cheyadam or tappul lekal veyadam. Misappropriation of funds. Giving wrong legal advice to a client. Only if you have a thorough knowledge of the law and the case, then only you can accept it. If not, you may land up giving a wrong advice. Meeke తెలియదు rule position ఏమి అనేసి. Best example I can give you here is, I'll take family law example. When a Mohammedan approaches you, what is the first thing you need to? When a Mohammedan approaches you, you are an advocate. You need to find out whether he is a Shia or a Sunni. That is the first thing you need to make out. Because two have different laws, different rules. So you cannot apply Shia law to a Sunni and Sunni law to a Shia. So you have to be thorough with the basic facts and all. Then only you can apply the law. Otherwise, Sunni వచ్చినప్పుడు మీరు షియా లా కానీ అప్లై చేస్తున్నారు అంటే ఒక రాంగ్ అడ్వైస్ ఇచ్చినట్లే కదా అంతే. Next time the said client will not refer your name to anyone. That will be your last case. Case కూడా కాదు. Okay. And next, changing sides. Yesterday we have seen. Okay. అపోనెంట్ కి మార్చుకుంటూ వెళ్ళడం, అతను ఇంత ఇస్తానడం, డబ్బులు ఎక్కువగా ఇస్తాడు, వెళ్ళిపోతారు. నెక్స్ట్, an indecent cross examination. There is a method that need to be observed by an advocate during chief and cross. So generally cross examination అంటే కొంచెం రఫ్ గా ఉంటుంది. So during cross examination, whatever the advocate wants to do during cross has to maintain some decency and should respect the other party's stage. Next, failure to attend the trial, attesting forged affidavits. 13th, committing contempt of court. Contempt of court, what amounts to contempt? Contempt of court, court ధిక్కరణ, non-compliance of order, non-compliance of court order. Avuna? That is contempt of court. And next, misleading the court, resulting in erroneous order, decision. As an advocate, you have to be very transparent with regard to the position, your position, the law, etc., etc. You cannot mislead the judge. You cannot mislead a judge. Antlani, judges anta idiga undaru vallu. Okay, they are very cautious. Meekana chaala jagattaga untaru. They do research. There are internship annam kada. Meer annare. There are students. Vallakantu assist చేసేవాళ్ళు. వాళ్ళ ఛాంబర్స్ వెళ్ళి ఒక కేసు గురించి అన్ని డీటెయిల్స్ ఇచ్చేది వాళ్ళ పనే. Okay. And next, abstaining from appearing in court on the ground of strike. On the ground of strike. So what happens if an advocate involves in this act of strike and he has abstained himself from attending the court, attending the cases? Client will suffer. There are situations where client represents on his own. He can make his own representations. Okay. So here it depends. This particular point depends on the relation between the bar and the bench. there are few judges who consider the act of strike. There are judges who are against this. So it depends. It depends. ఇక్కడ తిరుపతిలో కూడా జరిగింది అవునా ఇప్పుడిప్పుడే రెజ్యూమ్ అయింది వర్క్ and it all depends on the relation between the advocates to a particular case. Opposite advocate ఈ advocate వాళ్ళిద్దరి మధ్యలో అండర్స్టాండింగ్ ఉండింది అని అంటే ప్రాబ్లం రాదు. ఒకవేళ ఈవెన్ జడ్జ్ డిస్మిస్ దెన్ వీళ్ళిద్దరు అండర్స్టాండింగ్ లో నేను మళ్ళీ వేస్తాను ఫైల్ చేస్తాను నో కౌంటర్ చెప్పాలి. నో కౌంటర్ అంటే అయిపోయింది యాక్సెప్ట్ చేసుకున్నట్టే మళ్ళీ అవునా జరిగేదే కదా. So these are all the instances of professional misconduct. And next, coming to the punishment for professional misconduct. An authority to entertain the grievances is, who is the authority that entertains the grievances? Disciplinary Committee of Bar Council, State Bar Council and Bar Council of India. Okay, and so what are the different kinds of punishments here that an advocate is liable to face because of his misconduct? A punishment can be a reprimand. What do you mean by reprimand? Reprimand, Vinnara? Temporarily. Okay. Temporarily. Next. Any other answer? Reprimand. A warning, a sort of warning. ఇది ఫస్ట్ డిసిప్లినరీ కమిటీ ముందు వచ్చిన ఒక ఫస్ట్ ఇన్స్టెన్స్ అనుకుంటే ఇట్ జస్ట్ వాంట్స్ అన్ అడ్వకేట్ డిపెండింగ్ ఆన్ ద గ్రేవిటీ ఆఫ్ సిచ్యువేషన్. ఫస్ట్ టైం ఎలా ఉండొచ్చును ఇట్ డిపెండ్స్ ఆన్ ది గ్రేవిటీ ఆఫ్ మిస్కాండక్ట్. వాట్ సార్ట్ ఆఫ్ మిస్కాండక్ట్ ఇట్ ఇస్, వాట్ సార్ట్ ఆఫ్ యాక్షన్ దట్ నీడ్ టు బి టేక్ అగైన్స్ దిస్ అడ్వకేట్ అనేది దానిపైన బేస్ చేసుకొని ఉంటుంది. సో ద ఫస్ట్ ఇస్ reprimand. It can be a just warning, a lesser sort of punishment we can say. And next is suspend. He can be suspended. Suspension is again for a period, only for a certain period. So during the period of suspension, he is not permitted to practice, not permitted to entertain case, not permitted to represent during the period of suspension. The next is, what is the third one? Removal. That is the last stage. Warning ichi venaledu. Again, he is accused of some sort of misconduct, one or the other example. Okay, suspension aindi. And the misconduct continues, and the last step which is considered as removal of name from the role, advocate's role. He is removed permanently. Arthamainda? So these are all the three different forms of punishment. Penal provision. And what is the remedy that an advocate who is proved guilty of misconduct? What is the remedy that is available to an advocate? He can go for appeal and review. Appeal and review. So, what is an appeal? Final sem lo adigina final sem students ni adagalsina question kaadu idi appeal ante emi ani. But what appeal is?
Is there any period? A limitation period అన్నిటికీ ఉంటుంది కదా, మీరు చదివే ఉన్నారు. CPC including limitation act. So what is the period? 60 days. Ah. 60 days. అంతేనా? 60 days. The last rows మీకు చాలా అవసరం ప్రొఫెషనల్ మిస్కాండక్ట్ గురించి. For your benefit only, we are discussing this. Only for your benefit. And so, appeal and review. These are the two options available to an advocate who is proved guilty of misconduct. He can prefer an appeal. If an advocate is not satisfied with the order passed by Bar Council, he can prefer an appeal. And aggrieved by the order of Bar Council of India, an appeal is preferred to the Supreme Court. Hierarchy. And next, the option is review. A petition can be filed to review the punishment, the case, the disciplinary action that is taken by the committee. After considering the facts, it may uphold the punishment, or can reduce or increase, which means modify. There are chances of modification and alteration in the punishment, penalty, and sometimes a complete penalty can be struck down. లేకుండా కూడా చేసేయచ్చు. This is all about professional misconduct. Okay? Tomorrow I'll discuss. What should I discuss tomorrow? Bar and bench relations, Valdama. Bar and bench. Or you want to know the other options? When can we discuss that? No concluding statement. Which court has decided? Supreme Court. Supreme Court held client is a consumer. In which year? 2007. Any other judgment at later date stating client is not a consumer and a so the latest prevails. And so an advocate can be charged for deficiency of service in under Consumer Protection Act. Antena? Double penalty appudu. Double penalty? No. The same punishment. That's what I'm asking you. ఇప్పుడు చెప్పేది కాదు 2 minutes లో బికాస్ యూ హ్యావ్ వాస్ట్ ఆప్షన్స్ చాలా ఉన్నాయి. అట్ ద ఎండ్ షాల్ వి డిస్కస్ ఆర్ వాట్? అట్ ద ఎండ్ వి విల్ డిస్కస్. మధ్యలో చెప్తే బాగుంటుంది బికాస్ అది మన సిలబస్ కి లేదు కాబట్టి.
Class. So last class we have a refresh of our memory. So last class we have refreshed our memory regarding what is crime, what is offense, what is punishment. We already discussed in the your IPC, CRPC and all. So today we are going to discuss about the dimensions of crime. That means when a person committed a crime, why that person is committing it and what is the factor for doing that thing. Okay. So basically when we are discussing about it, two factors mainly comes. That is, one is social factor, another one is economic factor. So first, come to the social factor. Social factor in social factor, four things mainly comes, which is a factor for the commission of a crime. Age, class, gender, and race. First, come to the age factor. Okay. If you go to the society, if you see it practically, mostly a person, that means a person who is in his early teenagers or who what we call as adolescents, they are mostly prone to the crime. When the age is increased, the criminality nature is decreased. That means it is mostly reversely proportional to your crime. Why the early teens are more prone to crimes? Yes. That you call it a kid decade while they are experimenting on different things. Okay, if I do this thing, what is happened? If I do that thing, what is happened? Let's see. That give them the key to commit a crime. And later on, when the age increases, then criminality nature becomes decreases. General, but every general rule has an exception. Some due to education, due to their environment, may leave that path, criminality path, or sometimes when they don't get any proper education, proper environment to commit environment, they live in that particular way onwards. Okay? So, as I told you, the peak year for the offense is mostly 8 to 14, early teenagers or adolescent ages. After that, that offense mostly goes to till late teenagers. That means 18, 19 years till that goes on. And after that, they decreases.
That is the where the mostly effect you started as a kid. When you try to start different things, mostly when you are in the adolescent ages, you want to try different things. Most of us, I think, start to ride a bike in that age only, 13, 14, 15, that time. Yes or no? Later on, okay, let's try new things. That is kids, which also gives us during the committing a crime. And we can control that thing by giving them a proper education and proper environment where they can decide themselves, okay, if I do this thing, the consequences this. If we do this thing, consequences this. So we can teach them in an early age that, okay, what you are doing is the wrong thing. That's the end. Next one is class offenses. In class offenses, if you saw the society, whole society, it is divided in different classes, upper class, lower class. Sorry, upper class, middle class, lower class. Yes or no? Between that also, upper class is divided, middle class is also divided, and lower class is also divided. Those who are in the upper class, upper class, mostly upper class, lower class. Upper class, like those companies and tatas, they are those who work from their boss, they are billionaires. Yes. Lower upper class, those are newly become billionaires. If you take the example of that retail Agarwal, actor retail Agarwal, that your oil company, that one. Those are the that starting those people, those who are coming. First generation billionaires. So that family, they are born with a silver. So mostly they are not come for the traditional crimes. They are crimes in something different, which is otherwise known as bank crimes. Okay, not our discussion, part of discussion. Then come to the middle class group. It is again divided mostly upper middle class, lower middle class. Upper middle class, we need a very good house, we need a very good car. Lower middle class, we need a very good land. And for that thing, we can do anything. Bribery, tax matching, all that things out of this need only. Same as if you go to the lower class only one plus lower class. Okay, there is no specification. Those who are mostly daily wages and all that kind of people are there. Those who need to survive the day. For that survival, they can do anything. For that survival, they can go for a crime also. Yes or no? I need food. Yesterday I gave you the example, motive and intention, part of motive and intention. Some even some that survival, the criminal fact also introduced. Like your narcotics, drugs abuse, all that things comes. Today, like I am a lower class. Example, I am coming from a lower class family, or where my survival depends on my daily wages. Something happened in my family. For that, I need money. How I am getting that money? Nothing comes to my mind but steal someone. So, this, if you go to the CRP, National Crime Record Bureau, you can find out most of the criminals, those who are involved in the traditional crimes, snatching, stealing, dacoity, all that kind of things, or which is related to drugs kind of thing. Those are coming from the slum areas. Most of the cases. Criminals are from the slum areas. Same thing if you go to the jail visit in your this semester, there is a jail visit is also there. You can find out most of the jail inmates, those who are this category of the people, they are from that slum areas. But if you go to the age factor, previously what we are discussing, in age factor, you don't find out any person. No, it is not about class. It is itself a factor. They don't need any, what you call it, class factor. It is not affecting them. That important. रईसों का विग्रह हुआ होगा. In English, it is used as a slang, reskilled brass. BRAD. It is a slang actually. Okay, sorry to say that word. But if that they don't need that have money, their parents have money, but they need kick to commit while they are committing a crime. That's all. So take the report of jail. Mostly those who are involved, either they are coming from the slum areas, or most of the times those youngsters who are there, they don't have any relation with the social structures and all that things. They just need kicks, they need something which gives them kicks, temporary kicks or something. They are from the rich families. That's the point. These are the some points regarding this thing. Next one, gender. Use your common sense. If you go to the jail, most of the inmates are male or female. Why? In IPC, he and C both are represent to that. So he represent to both men and female. Go to the general explanation. Yes, because when this penal provisions are there, from when penal provisions are there, recently it is amended in the name of that Bharatiya Nyaya Sanhita. Yes, no, recently in 2023, which is going to be implemented from the 4th of July. Before that, our penal provision mostly it is from the 1860. At that time, our social conception is that a female cannot commit a crime. That is our social conception. Later on, in very small places, it is found out that, or after new amendments, in some point of places, they make that particular crime as a gender neutral, because sometimes they found out that a female can also be joined in that case. They make it gender neutral. But those who are from males, it is not made gender neutral. It is still for the males only, not for females. So my point is, let's number of female inmates in the jail is only because of our social structure. Till now, if you find out in your house, it is mostly a patriarchal family. Our father take all my mother take all the decision in my family. So as to yours, most of the cases. Yes or no? So it is our social structure which demand the females to commit any crime. But society is also changing regarding the crime. For that, in some point of time, they are committing a very specific crimes. Their crimes are mostly based on the revenge. If anybody does something to them, or a crime is committed by them in a revenge, very small fraction of the crimes are there where they are associated with a group to commit a crime. For example, most of you are from Tamil, yes or no? When you are coming by car, you are coming by car in the night. In the highway, you find out that a female is there who is asking you for a lift. You stop the car. A group comes to you, robbers. That means that female is like a way to you to stop your car so they can rob you. They are associated with the females are associated with the other groups to commit a crime. After that also, whoever you are, if a female crime for you, in Hindi, cycle of गाली निकल जाएगा. Yes or no? Man is saying yes. So, most of the time also, against them, the case is not registered. Sir, I'm very hungry, sir, I have to feed my child, I have to say some sad stories. Similar, okay, police, okay, go. Excuse. Like that. Also, these courts are also a very reason there is a very small inmates in the jail or very small female criminals in the jail. So here, here
5223 166. 5223 166. Money content thing. 5223 166. Money content.
general 5223
166.
166 money content. Anybody? 5223 166.
Who is money content? Come here. Nothing.
So this is some your data regarding the female evolution, gender evolution. Last one is our race. How many of you saw that film Jelly? Almost everyone. So, sir, it is already in your gallery. Already in your gallery. Jelly, what is the main thing is there? Habeas corpus, okay, but the main thing is police officer they detain some jungle dweller, forest dweller. And for that hero Surya, that is the main thing. But why this thing happened? One thing, discrimination. Till now, Till now, if you go to some interiors, you'll find out interior villages areas, tribals or something. Higher class people, they don't allow the lower class people to stay in there, to come inside their house. Take for example your village. At your father's time, when your father is at your age, ask them if there is a fish. First, higher class people they seek for the fish. After their completion of their lower class people are coming. Why this kind of thing? This discrimination most of the time leads to a organized crime. Yes or no? Lower class people cannot enter to the temple. Lower class people cannot take the water from the well. Lower class people cannot sit with us. This discrimination mostly leads to the crime, or we can, in other words, we can say that it is another factor to dominate a crime. That is a Marxist concept. Marxist concept. Why they are taking the gun in their hand? Discrimination by the government, by the state. Okay, let's go. Let's have a debate against the government. We are seeing what is done by them to us, but it is nobody care about what we did to them. There is, if you find out that Andhra, border areas of Andhra, borders to Tamil Nadu, borders to Telangana, sorry, not Telangana, Odisha. So you find out the places there is no proper road, no proper education, healthcare is not there, all that things. Why that kind of discrimination? If somebody is giving to them, if somebody is giving them food, they are going in favor of that person and those are houses. You are saying only we Marxist destroyed our Marxist to do this, that. But why that people are doing that thing? You have to eradicate that thing first. That is the point. Sorry, sir. Who is that? It's a new concept. I don't know. Language problem, that's why I can't see that well. If it is dubbed to Hindi, then only. Okay. Now, come to another dimension, that is the economics, which is mostly set for higher class people. Financial services, or otherwise known as the white collar crime. What is white collar crime? Why is it called as a white color? Why not other color? No, it is not like that. When this term is given in 1837, to maintain a white color is very difficult. So, it is very difficult to maintain a white shirt. But at that moment, at that time, it is too difficult to maintain. That's why only the higher class people can afford this thing. And the crimes done by the higher class people known as white collar crimes. And they don't do mostly the financial crimes. But later on, when should go, sir. Yes. So later on it is found out that anybody can commit a financial crime. Take example that stamp paper scam, your that Satyam, or that stock market, so mostly anybody can. That stamp paper scam is done by a fruitless seller. So that thing. So later on it is find out that anybody can commit that crime, and mostly your crime. No political comments. So mostly economic crimes are done by a singular or by an organization. If you take the Harshad Mehta case, then he has one group, his brother, another his friend, and some groups are there who collectively committed in 1992 scam. But if you take to this fruit seller that your scam stamp paper scam, this is similarly he has a printing press and he started to print the stamp papers. Singularly, and mostly it is done to commit the economic offenses for your gain, economic gain. By that way, if you are committing that kind of economic offenses, there are some impact on the nation's economy also. Mostly the budget, mostly some lakhs crore, yes or no? Financial budget of country, some lakhs crore. And out of that, if there is a 2G scam is how much crore? Some thousand crores or something. Like that, if that kind of offenses are committed, and out of budget, that thing has to be repaid also. What is the effect on the country's economy? These are the impacts. Inflation, uneven distribution of resources, tax, all that things comes to the economy. Yes or no? So, if we go through this kind of factors, these factors always there. Though it is social, economic, some people think can find out. It is not a honor. You can find out this kind of people. Those who are committing these kind of offenses. Till the end of the world, there is discrimination is there. Any kind of discrimination. If you eradicate all discrimination, they find out some new discrimination. You can find out some greedy people are there who need what? If they have all the money, still they need more money. You can find out. So, we cannot completely eradicate a crime from the society. We only can check that crime. And how that thing can be possible? To stop it, we need a proper data that where this kind of offenses are happening, and that thing can be done by the taking the statistics, crime statistics. So mostly statistics of the collection of the data figure regarding the conditions of the people, class, and all that things. If we can find out that thing, we can mostly suppress the crime, or we can somehow check the crime before it has been committed. Like, if you take that person Mehta case, why he can commit it? Why he can commit that kind of scam at that time? Because it is all done in the manual form. All that bonds, sovereigns, all are done in a manual form. But right now, it is electronic form, single database. So all the data are there, and in a single click, banks can check the record like that way. If I know that then just the people mostly coming, most of the drugs, most of the snatchers are coming from that slum. Give them proper education, give them proper medical facility. In that case, we can stop that people from that slum to commit the crime. So we need data to control the crime. That is the statistics. And that can be done only by the statistics, crime statistics. So why we need it? For these two reasons we need the crime statistics. What I already told you. To formulate a social policy where or theories of criminality, second one, we can, after doing a field research, we can, or the legislators can bring a new law that to control that crime. Take an example of that Nirbhaya case. Only after Nirbhaya case, it comes to our legislation's mind that no, a 16-year kid can also do that kind of heinous crime. So, for the heinous crime, they reduce the age of the minority from 18 to 16. Yes or no? That's why we need the crime. But the question comes, can we rely on this kind of crime? Sorry, this kind of reports of statistics? Most of the cases, no. Because reporting of crime, most of the time victims, they don't want to involve in any kind of legal procedure. They are not giving the proper report to the system, so where we can collect the data. First reason. Second reason, whole system. For take an example of a police station. If lesser number of cases are coming to that police station, it is a very good police station. Yes or no? That's why most of the time if you go, go. They are not registering the case because they need lesser number of cases in their area. Third one, conviction rate. If I file a case for theft of my bike, the conviction when happened, I don't know about that. In a criminal case, example of the civil case, generation will be good on that one case. That is the another reason. sometimes what is the judicially they are giving the report, okay, in this year or in this month we are convicted this much or we are disposed of this much cases. Same report is not only going to the report given by the jailer. Not as much of criminals are here, or more criminals are here, less criminals are here. There is not a tally between the judicial, what is the judicial is giving and what is the jail is giving, custody is giving. So these are some reasons where sometimes we cannot rely on the statistics which is available to us. So this is for today. Tomorrow we are going to discuss about how a crime is reported and other things of this regarding this class. Thank you and have a good day. Good afternoon, dear students. Today we get the details information about your court visit. So please have patience and note it down. And also afternoon, general students, you have to come to college to collect your chamber diary. Without chamber diary, you are not allowed to go to court. Every day, what you learn there, in which court you attended, you will record it. So by what time, expert or the subject expert, external will ask, verify your chamber diary. And from there, you will ask questions or she will ask questions. External. By what time? So daily, whenever you are going there, which court you attended and which case the trial procedure was there or something that you kindly note down there. Okay. So and the rest of things will be announced by my esteemed colleague, Professor Dheeraj Srinivas. Over to you, sir. Thank you. A very good morning, all of you. I hope you all are enjoying classes. No. Yes. No. Yes. Yes, you are not enjoying classes. Okay. There is a small announcement for you all. You all are aware that from tomorrow onwards, your court visit begins. So, during the court visit, we have planned one like group A and group B. Group A will be going in the morning